Good morning, everybody. If I could just have your attention, we're going to begin the program. My name is Michael Most, and I'm the National Director of Public Affairs for B'nai Brith Canada, based up in Ottawa. I'm filling in for Frank Diamond. Frank was hoping to be here this morning. Unfortunately, a very urgent personal matter just arose, and he's unable to join us this morning. He regrets it, and he wishes that he could have been here with us. I'd like to begin by thanking Charles Wagner, Rachel Blumenfeld, Ian Hullen, and Ada Bromberg for the endless professional hours they invested in preparation of the Law Journal. I'd also like to say a special thank you to Hyla Reichman, who for putting together this wonderful breakfast and ensuring all that the preparations this morning were first class. Also like to thank Norm, Dan, and Bonnie from B'nai Brith. And lastly, I'd like to thank Scotia Private Client Group, who's represented here by John Clegg this morning from Estate Trust Litigation and Guardian Solutions. Scotiabank Private Group is our event co-sponsor. B'nai Brith has been active in Canada for over 135 years. Our mission statement is simple. It's people helping people. B'nai Brith is about community service. B'nai Brith is about human rights protection, prevention and advocacy, both at home and abroad. B'nai Brith is about sports, baseball, basketball, hockey, and soccer. B'nai Brith is also about communication. The Jewish Tribune is circulated to 63,000 homes and has a weekly readership of approximately 120,000 readers. We are proud of our Lawyers Division, which focuses on issues of importance to Canadians in general and to Canadian Jews in particular. These seminars, offered by our Estate and Trust Group, are intended to help our lawyers, accountants, and estate planners in serving the Jewish community by sharing their experiences through continuing education. By bringing you all together in such a forum, we hope you will be better enabled to service our community. We anticipate that the knowledge of private international law issues and estates that you will hear today will help you in being better prepared to deal with your clients whose assets are not limited to local jurisdictions. I'd now like to bring up Luna Roth, who is the president of B'nai Brith Foundation, and she will introduce the first speakers.
First speaker is our organizer, which is Charles B. Wagner. Charles is an experienced estate litigator combining an assertive approach to litigation with a keen understanding of business. His legal practice focuses on disputes related to will challenges, capacity litigation, executor removals, support claims, and other related estate litigation. Called to the bar in 1985, Charles is the chair of the Estate and Trust Group, Lawyers Division of B'nai Brith, president of the Thornhill Jewish Chamber of Commerce, and the former CEO and corporate counsel of Success Business College. Equally at home in the courts or business boardrooms, his success is built on the ability to make strategically prudent legal and business decisions in highly pressured situations. Recognized by his peers and clients as being a savvy, aggressive, and successful estate litigator, Charles B. Wagner's law office measures its success by how effectively it fulfills its mission to the community. This law office's goal is forcefully championed to their clients with effective and innovative legal solutions, having the client's best interest in mind. Charles? Is live with us from Tel Aviv, or is it Jerusalem? It's from Jerusalem. Michael is with Raphael, Efrati Law Office in Tel Aviv. He specializes in English language contracts for the high-tech industry. Before joining the firm, he was an independent practitioner in Jerusalem, representing foreign and Israeli clients in matters related to contracts, estates, corporate, and other commercial matters. He is a member of the boards of several Israeli companies and a member of both the Law Society of Upper Canada in 1979 and the Israel Bar Association in 1981. He received his law degree from the University of Toronto, where he also earned a Master's of Science degree in mathematics. So, live from Jerusalem, Michael and Charles Wagner, present in the room.
Good morning. Just some housekeeping matters. I also wanted to take a moment to thank our other presenters here today, Jordan Ayton and Dr. Ken Schulman. They are of immeasurable help to me in my practice, as are the other speakers. Whenever I have a problem, I don't hesitate to call them. And their kindness to me in my practice is immeasurable. And I should say to the practice generally. I'm very honored to be with presenting with the speakers here. The other thing I'd like to start off by saying is I feel a little bit ill at ease because I've noticed that everybody's been staring at me a little bit since I've come in the room. And I know what you're thinking. You're wondering, what's wrong with Charles's tie? I like my blue tie. All right. And I'd also like to introduce Rafi Soto, who's a student of mine at my office, a summer student, and he's helping me out here today. Rafi, could you just put the first placard up when we start? Michael, can you hear me well? I guess.
I hear you, yes.
Excellent. Michael and I...
Can you hear me?
Yes, I can. So Michael and I worked together on this article, and I've benefited a lot and learned a lot from him as well. So let's start off by saying that as the world shrinks, we professionals are increasingly called upon to deal with estate issues that are multi-jurisdictional. People own properties all over the world today, and our law has to deal with it. My paper and Michael's paper addresses one such scenario. So let me paint the scenario for you. Max resided in Toronto. He was a Canadian citizen. He owns 2 houses in Ontario. He also has $2 million at the TD at Bathurst and Wilson. As we say in Latin, Norf insgezocht. Last year, he moved to Israel. Max buys a home in Yamini Moshe in Jerusalem. He also purchases a will kit off the internet. Max, at his daughter's bequest, goes over to his neighbors and he signs the will. But only one neighbor signs as a witness. 8 months later, Max dies, and his daughter wants to probate the will. You are the professional, and his daughter approaches you and she asks you these questions. Can this will be probated in Ontario? The answer? Maybe. Can and should this will be probated in Israel? The answer? Definitely. Can a testamentary document be probated first in Israel and then resealed in Ontario? Yes. Now, you're the Ontario lawyer. The first thing that strikes you is that we have jurisdiction because there's land here in Ontario. There are 2 houses. And if there's jurisdiction, if there's land in Ontario, we have jurisdiction. But the first thing that strikes you is we have a problem with the formalities of execution. Now, I'm just pointing out here, Michael, you can't see this, but I have a placard here of the Succession Law Reform Act, and in particular, Section 4. In Ontario, there are rules that deal with the formalities of execution with the will. And in accordance with Section 4, there are a number of things that have to be done in order for a will to be valid. And one of the formalities of execution is that 2 or more of the attesting witnesses subscribe the will in the presence of the testator. And if I translate that into English, it means that after the testator signs the will in the presence of 2 witnesses, they have to see him sign the will, and they have to sign the will afterwards. Clearly, in our fact situation, it seems as if the will does not comply with the formalities of execution. Now, there is case law in Ontario that suggests that substantial compliance with the formality of execution is okay. But that case law is in the minority. The generally accepted view is that Ontario courts do not have the discretion to dispense with the formalities of execution as set out in the Succession Law Reform Act. And I want to be clear about something. Other provinces have different statutory setworks. Other provinces have incorporated substantial compliance. But in Ontario, I think the case that sets it out best for me is the Ettore Estate case, where Justice Cullity, who I consider one of the best judges we've had in the Estates Bar, sets out that in the absence of a legislative mandate allowing for substantial compliance, it would radically depart from the case that we've had up to date. And we have mandatory full compliance with the formalities of execution to prevent fraud. So until the Court of Appeal or the legislator says different, in my view, and in Justice Cully's view, so I'm in good company, you require full compliance with the formalities of execution. So the bottom line is, and I'm dealing with a normal situation where there's a will in Ontario, where a testator is domiciled in Ontario, such a will with only one witness would not be able to be brought to probate. Now, that raises the question of Israel. What are because don't forget the three questions that have been posed to you. The first question was, could this be probated in Ontario? And the answer still is, because we haven't dealt with a private international law issue, maybe. Could it be probated in Israel? And for that, Michael, I turn the podium over to you.